Adjournment request, if any, from item number 1 to 7.
My lords, I beg to mention item number 6, my lords. And there's a PIL, my lords, I seek apology, my lords. We are directed to file an affidavit, my lord. We received some bulky instructions last evening only. My lord, 2 weeks may be granted.
Who is for the other side?
I have informed him, my lord. Yesterday we have
2 weeks.
2 weeks. Only.
Yes.
Item number 8 to 14. Item number 15 to 28.
Big resolution. My lord, I beg to mention item number 18, my lord.
15.
Here, your lordship, permit me to furnish some additional information in the PIL. So I pray 3 weeks time.
This is the state appeal. Item number 15 is state appeal.
No, 18, my lord, 1/8.
1/8
My lord.
PIL,
Yeah.
Mumtaz Foundation.
Yeah.
Yeah, you are supposed to file some better particulars without there being any details. Last time.
Yes, my lord. That is why your lordship was pleased to give me some time. Now, my lord, I have gathered and further I want some time. My lord. 3 weeks time.
Petitioner pays 3 weeks for the time to furnish better particulars in support of the claim made in the PIL petition. Just after 3 weeks.
Lovely.
Yes.
Lordship, with lordships, but I'd like to mention item number 15 it is a state's appeal, fresh appeal, lordship. Lordship, I am in the midst of a day-to-day hearing in court number 5. Today is the last date. In fact, it was supposed to be over yesterday. It prolonged today. So it will be very, next week, lordship.
Next.
15 as well as 36 also.
My lord, in item number 15, we have been instructed by the respondent petitioner to appear. I am praying for a copy, my lord.
I'll give you a copy, lordship.
Item number,
1/5.
another item number
36, lordship.
36.
36.
This is,
This is a hearing matter, lordship. Any day, lordship. Subject to lordship's
you are
convenience.
for the
I am for the appellant.
appellant.
Yes, Lord. In both the cases, I am for the appellant.
Appellant,
Because I am appellant because it's a Mizoram matter, Lord.
Mizoram. 36,
36.
Arjun.
Highly obliged, Lord. I have taken the consent of the other side also. Deeply obliged.
May I please, your lordship. Lordship, I beg to mention item number 19. I pray for 2 weeks further time to file the affidavit in reply to.
You have to satisfy many things. These PILs, is 4 weeks, at the request of land consent of the, so the, get the.
Yes. Thank you.
Agenda. The request of the land consent of that. None. Just after 2 weeks.
Obliged.
May it please, your Lordship. I'm praying for adjourning item number 24, Lordship. I have taken consent from the other side. Lordship, I'm appearing for response number 4 in this case, and I need at least 10 days time to file my affidavit, Lordship.
Adjourn. 2 weeks.
Obliged, Lordship.
May please, your lordship, with the consent of the other side, I beg to mention item number 23, my lord.
Yeah.
Mr. ARV has some medical difficulties, my lord. For adjournment for today only, my lord, or next week, any hearing that, my lord.
Next week.
Highly obliged.
Wait, please, your lordship. My lord, I beg to mention for listing of PIL, lordship, on Monday or Tuesday.
What's the urgency in the PA?
Lordship, urgency is that, lordship, I have preferred this PIL, lordship, regarding auction of the seized battle nuts which are unfit for human
Auction of the
consumption.
seas?
Seized battle nuts, lordship, which are unfit for human consumption. But that was sold through auction, lordship, in the open market, lordship, which creates public health hazards, lordship. So, and on 26th, lordship, another lot of auction was going to be opened, lordship. So, lordship, there are some ideas.
How do you come to the conclusion that it is unfit for consumption of the human being?
That was itself mentioned in the auction notice also, lordship. That was unfit for human consumption, but it will be sold, bidders were lordship, invited lordship, but no restrictions was put lordship.
Can
That-
be used for some other purposes also?
Lordship, that has to be, there is an SOP of the government of Assam lordship, as per which lordship, that has to be sold to the industries only lordship. But that restriction was not given lordship. So there is a, lordship, earlier also that was happened lordship, that was open, sold in the open market lordship, which creates severe health issues to the people, common people lordship. That's why I have preferred this PIL.
Meet with your lordship. Lordship, in respect of item number 17, my lord, with the consent of other side, my lord, I pray that 2 weeks may be allowed, my lord. We have to file an RTI, my lord. We have to bring on record certain RTIs, my lord, in respect of item number 17.
70. To satisfy regarding the maintainability of the
Correctly.
PIL, sir.
Yes, my lord. My lord, in that respect, your lordship had raised
Because
the
your
query.
challenge here, essentially the promotion to the private respondent.
Yes, my lord. My lord,
Should
here
not
we
be a
have sought the
service that,
RTI. My lord, here we have sought the RTI from the superintendents of the
What's
vigilance
the RTI?
department.
Maintainability,
Correct, my lord.
we are asking your focus.
My lord, in that respect, my lord, we have sought certain RTI from the vigilance department. That's your lordship has raised a query on the last occasion that whether these inquiries are pending or not. What came from the other side was that, my lord.
Last order sheet is this. When council appearing for the petitioner has to satisfy on the maintainability on the next date of.
Correctly, my lord. Correctly, my lord. In that respect, my lord.
That, yes, you can challenge the promotion of a individual.
My
on a
lord, we are
particular
not challenging.
post. Purely a service.
If I may
matter.
respectfully submit, my lord, we are not challenging the promotion of that person.
That
There are
you-
certain
You
inquiries,
have,
my lord.
you already argued and prima facie we have observed that
my lord.
essentially it's a challenge to the promotion to the private respondent only and nothing
Correctly, my lord.
else.
Correctly, my lord, but we have to, my lord, we certain inquiries we had made to the RTI, my lord. Sir,
Very, apart from that,
yes, my lord.
your challenge is only to the promotion of the private respondent. And certainly for that, it is not.
Correctly, my lord, but that respect, my lord, there
Correct,
was a
that what
DPS, my lord.
remains.
My lord, we have disputed certain, my lord, inquiries which were held against this person.
That's altogether a different part.
My lord, I'm
In
just
this
saying, my lord, that
petition, you have challenged the
affidavit
promotion of
we-
a individual.
my lord,
on a
only that
particular
affidavit to be on
post.
record, my lord.
When consent for the petitioner takes some more time to satisfy this court regarding the maintainability of the PIL on the next date of hearing. This after 6 weeks.
Highly obliged, my lord.
May I please your lordship? With consent of the opposite parties, I pray for an adjournment in item number 26, 27, and 28, my lord. I need 2 weeks time to file my affidavit.
26,
26, 27, 28.
these all are three connected matters. You are claiming parity, you are the tutors and claiming parity with the teachers.
Yes,
Yes, I'm for the petition.
You are for the petitioner.
Yes. Government has to file it.
How would you argue the matter in this? What remains? Taking time.
Discrimination between the alleged discrimination between the teacher and the tutor is already a subject matter before the special review which is being taken up today. They have argued that they could not have been a
This very same
differentiation.
provision is under challenge.
My lord, not the exact provision here. They have said that the salary should be kept at par, or at least a minimum wage should be given. But there, the issue is whether we should treat them at par for all purposes, including salary. Some observation, if it comes from the special levy, my lord, may affect this.
6 weeks, adjourn.
No pleasure.
May I please the Lordship? Lordship, I pray for listing of a writ appeal, Lordship, regarding non-payment of pension, Lordship. And another is,
Next Wednesday or the Friday.
Friday. Next Friday, 26.
Lordship, and another is of repetition against the Kate order, Lordship,
Against the,
against the Central Administrative Tribunal order.
26, same.
Obliged, Lordship.
May I please, your Lordship? Lordship, I beg to mention item number 37. In this matter, earlier, Lordship, senior advocate and now Justice Utena was represented in this.
it's a
case.
hearing matter.
Yes, your Lordship.
So,
Lordship, so far the client is concerned, they will engage some senior advocate in this case, because earlier this case was led by
It will remain
Justice.
on the board. It will remain on the board, hearing matters. No. Pass over for today. Engage any other conflict. Pass over for today.
Yes, your Lordship.
May
Hello.
it please your Lordship, I beg to mention item number 31, Lordship. In this case, we want to file an affidavit in opposition, Lordship, additional affidavit, Lordship. I am for appellant, Lordship, I am appearing for appellant, Lordship. 2 weeks time required to file the same.
2
Lordship.
weeks. Yes.
My lord, I beg to mention item number 38, my lord. My senior is on medical leave, my lord. To leave,
38,
my lord,
38,
38.
pass over for the day.
May it please your Lordship. With the consent of the other side, I beg to mention item numbers 39 and 40, your Lordship. My senior is out of station. I'm praying for an accommodation for the day, your Lordship.
Adjourn.
Much
4
obliged.
weeks. Adjourn.
May it please the Lordship. Lordship, may I pray for listing of an interlocutory application for condonation of delay of 15 days in preparing the connected writ appeal.
Delay? Missed out. Huh? So is there any hurdle in listing those cases? The registry is not listing those such type of applications.
Mm,
Why are you seeking permission for that?
Lordship,
When you have moved this application,
we had filed it in the month of Lordship, June.
why they are? Inquiry to get it listed next week.
Yes. Orders, item 1.
May I please, your Lordship? Well, here we are basically the challenge, my lord, the notification at page 27, my lord.
Yeah.
Whereby, my lord, 5 my lord, villages.
Yeah.
Of the Kachar district, my lord, under the Katigora block.
Only on the ground that it would be inconvenient for the public at large, distance and anything else. Is
Well,
there
well,
any,
well, it's-
or the procedure which the government has not followed?
Well, it's causing inconvenience. It will cause
Inconvenience
inconvenience.
and
Because, my lord, what has
Yes,
happened, my lord, this particular areas are within the Kachar district, have got no attachment with Hailakandi district, number 1.
but the
Well,
election commission has said this, that so far as they are required to keep a assembly constituency in one of the parliamentary constituency, and for that purpose, this delimitation exercise is there.
My lord, that was because this was done to circumvent that with the provision, my lord. But then we are not, my lord, challenging the delimitation, my lord, because we are not challenging the delimitation process.
If you are not challenging the delimitation
Because,
and you are saying that exclude these 5 villages, then it.
no, my lord, what had happened, no, my lord, what had happened,
Delimitation.
no, my lord, what had happened, my lord, these villages were earlier there in the Kachar district, my lord.
Yeah.
It is only to bring them under, my lord, Hailakandi LAC now, this was done. That purpose has been achieved. We are more concerned, my lord, with our daily, with our routine activities, my lord, whereby the district administration now will be in with
You mean
Hailakandi.
to say that even though they're included in another district, but their whatever they should be under the revenue district of in another district.
My lord, that was the case. That is the position, because these villages are within, my lord, Kachar district, my lord. No, my lord, geographical continuity of the areas, my lord. Because this was filed before the limitation, my lord, delimitation process was initiated, my lord.
And our case is that this was to circumvent that provision of the delineation, my lord, that was done, my lord. So that this could be brought under the, my lord, new LSA.
What is it is the policy decision, the state has to take a
My
policy
lord,
decision.
right,
then
my lord, absolutely.
Tomorrow, some other villages will come, where they may also come and say, though it's far from their place, but the road connectivity is better and many things. Yeah, any person has any grievance regarding that.
My lord, our submission is, my lord,
These matters are, court
understand, my lord. But our submission is, my lord, that this were within the Kachar district, my lord, under the Kachar, my lord, administration. Now, my lord, 5 villages have been picked up, my lord, on a random basis, in a pick and choose method. All other areas are within Kachar district. We have been, my lord, picked up and brought on the high
You
my
say
lord.
that in between the Kachar district, middle of
Yes,
these villages have been.
yes,
picked up.
my lord. We've got no, there is no continuity, my lord.
Where is that map?
Yes, my lord. Map, of course, but they have admitted in the affidavit, my lord.
Show us the map that these
Map,
are
of course,
these
we have not
villages are
annexed.
situated here and.
My lord,
these
map,
villages have been
then,
picked
my
up
lord, I'll
from
to
there.
I'll to bring an additional affidavit, bring the map, because they have admitted the position, my lord, otherwise.
Satisfied.
So they have admitted, my lord. Lordship will see the affidavit page 94, my lord. They have, my lord, admitted that, my lord.
Admit, no need to issue notice as parties are represented in due course.
My lord.
Well, despite
Item number 2.
adjournment taken, no affidavit from the respondent side, my lord.
May I please, your lordship?
Yes,
Lordship, I'm representing respondent number 326, lordship.
so why
For
not filing reply?
lordship, for respondent number 3, lordship, we are filing our reply during the course of the day, lordship.
What
And-
about the state?
What we'll file it, my lord, within 2-3 days. By next week, we'll
My
file.
lord, 5 adjournment. 4.
What?
So, will I decide the matter without there being reply?
That's a little, my lord, their
Next-
report
next-
required.
You have to grant time to them.
And lordship, for respondent number 426, lordship, we need some time to file our reply, lordship.
Respondent number 3, you are filing reply, so why separate reply?
Lordship, actually, to bring on record, lordship, we are consulting some very old text, lordship, in the archive of the monastery, lordship. So, lordship, there are some technical difficulties we are facing. That's why, lordship, I humbly pray that some time will be granted for us.
It's a matter regarding entry of the women in the this temples. And that is by and large, how can you restrict your women?
Lordship, this is not a temple, lordship, this is a monastery. And lordship,
Even though the temple of the monastery of.
there are certain facts, lordship, which needs to be brought on record, lordship. Lordship, lordship, what I mean to say is this: the founder of the monastery was a celibate himself, and lordship, on those ethos.
My lord, the country is now governed by the Constitution of India.
Mr. So and so is appearing on behalf of the respondent number 1.
1 into 1.
So and so is appearing on behalf of the respondent number 3
3 to 6, 6.
What about 7?
7 means
7 is the
newly implemented respondent, newly implemented.
Newly implemented.
Notices have been issued to.
My lord,
He
see,
himself implemented.
see himself implemented and my lord participate the proceeding.
Respondent number 3 to 6. Respondent number 7 is represented through advocate Mr. B. Mahanta. Then counsel appearing for the respondent number 1 to 6. Please some time to file the reply. File the counsel to the writ petition. Time paid for is granted. After 4 weeks
My lord. Deeply.
I'm deeply obliged, lordship.
for admission. List of 4 weeks for admission.
My lord.
Item number 3.
Yeah, please, your lordship. This case, they have filed their affidavit, your lordship.
Yes,
Lordship, facts are like this, your lordship.
facts are very clear. You just tell us this, how this notification can be issued without resorting to the provision of section 4 of the Act of 1993.
Lordship, which notification, your lordship?
The notification whereby
There are
they
three
saved the proceedings during the time when the stay was in operation by the Rajasthan High Court.
Lordship.
That's the learned single judges said, you have no authority to do so until and unless any notification is issued
Lordship.
by the concerned authority.
Now, your lordship, what has happened here, your lordship? That during the period of stay, your lordship,
Yeah,
when this particular notification was, your lordship, in extinct, your lordship, we have to, your lordship, we don't have any other option than to file a petition.
so that's why only the learned single judges taken care of that.
Lordship.
And see the directions.
Lordship, I have seen, your lordship.
You have seen the directions. Even though they've granted you liberty to file, to issue a notification of this, they're saving those proceedings.
Lordship, that has been issued, your lordship. I have brought to the, brought that to record, your lordship.
When?
Your lordship, my additional affidavit, your lordship, may kindly. Page 126, your lordship.
126.
126 and 127. your
After this judgment,
lordship. During pendency of the present writ appeal, your lordship, this notification has been done.
section 4 of 1. Yes, Mr.
Lordship,
this notification which has come, your lordship, it is after around 8 months after the,
Whatever it may be, there is no limit for that. Once they have saved those proceedings, then what remains?
but if your lordship sees para 23 of the judgment,
Yes,
the first part clearly says that on that particular date, the learned single judge held that my case against the claim that was filed, at that point of time, DRT lost its jurisdiction.
it has to be adjudicated by the civil court,
Civil-
whatever it means, since
And-
the stay order was vacated. But at the same time,
The-
the learned single judge
Has asked them to pass appropriate
the
application.
respondent would be at liberty to issue, thereby further amending the notification, issue fresh notice, even taking care of those cases filed during so and so, whose trade value, so that,
Yes.
that they have done.
They have done, but your lordship, for 12 months, it is pending. They could have easily taken the step before the civil
That
court.
can't be, is there any time limit?
There is no time, your
No
lordship,
time
but
limit.
the
Then if they have
jurisdiction,
issued, then certainly those proceedings are saved.
a subsequent, it is there, the liberty was given to the central government and they have utilized that point. That is not in, I cannot doubt that. But the thing, my
There's
only
no question
submission
of
is your
doubt. The notification is there.
at the time when the judgment was passed, the judgment cannot be assailed on the ground of the subsequent notification. They have the power to file appropriate application now with a liberty, but OA, the original OA has lost its thing. They can be given because original OA,
Once all the proceedings, the learned single judge has said that thereby further amending, we should take care of the cases filed during the period of so and so who suit value below it at the applicable tribunal.
this notification,
The cases speaks
it
about
takes
the
care
cases
of that
which have
particular
already been
period.
pending before the applicable tribunal.
On the basis of this, it is there, no doubt, but it had been filed, but once the court, means my humble submission, your lordship, if it would have been still pending and the issue was before the DRT, this application could have been used before the DRT. But what I'm saying, your lordship, once court, great court has held that
Even though if this, after this judgment, if what we are subject to what you argue, even though if any proceedings which were transferred or returned back to the person who has filed this application has to be filed before the applicable tribunal in view of this notification. Sir. Now, the civil court has no jurisdiction, competent court of jurisdiction can't try that through in view of this notification until.
only for that particular period, yes, your lordship.
Particular period, until and unless this notification is challenged or reverts or whatever.
But I am just, understand your lordship. The only point I wanted to emphasize, your lordship, means
The delay part.
the delay part, your lordship.
Now.
No,
if they-
not
if
only
they fail
delay,
on
your
that-
lordship, what I'm trying to emphasize, which, because this notification says, which had been filed during this particular period. The latest
Their case
notification
was filed during that period.
had been filed. Now, what I am emphasizing upon, after the court, after the single judge passes the judgment on August, this particular filing became redundant at that point of time, your lordship. And they, because it is no longer pending before the DRT, your lordship. That is what means, I want to say that it is no longer filed before the DRT because that single judge has already held that this DRT did not have the jurisdiction. Does not,
Simultaneously, the single judge has granted them liberty to issue appropriate notification.
But it
saving
would be
those
with regard
proceedings, and they have done that.
no, they have done that with regard to those cases which are still pending.
Then the learned single judge should have clarified it. If within so and so time, then only it can be said, otherwise it would go.
Because
So
the first part, our particular case has been said that this court means there are three parts in the observation. You know. The first part says that OA 97 of two thousand
The
nineteen.
impugn communication stands set aside and quashed, and consequently that cannot adjudicate so and so.
Cannot
right.
adjudicate that particular.
The respondent would be at liberty to appropriate so and so, that the director will return the original claim. Now, we can't read these observations in isolation. It has to be read together. And if we go by that, then certainly.
That is true, Your Lord. Means I leave your lordship, means my only submission is this particular point with regard to that particular observation, because once the single judge held that this court did not, DRT did not have the jurisdiction, the filing of that particular case
But
during that period
but
lost.
granted to them that they can save that. That is there.
As your lordship, because there is, the only problem is, your lordship is aware with DRT, the civil court has a much
There
wider
is no
scope
question
of.
setting aside, there is no question of setting aside this judgment, but certainly we can take note of the subsequent development. Of that, no further order is required to be passed in this petition. As per the proceedings have to be commenced as per this new notification. So.
As your lordship. But solely on the basis of this particular notification or lordship, the subsequent notification, the interference is being made, your lordship. So the single judge's judgment per se was not.
No, certainly we are observing. This writ appeal is filed by appellant being agreed with the appellant being agreed with the order dated 31st of August 2023, passed by the London single judge in writ petition number 1842/2021. Para. The respondent number. Hearing the respondent number one, you are the respondent number?
Lordship, one, your lordship, Kannada.
1 and 2.
One in,
The respondent number 1 and 2 herein has approached the writ court with the grievance. Now, while challenging the communication dated 1/8/2019 issued by the respondent number 3 in the writ petition, that is under secretary to the Government of India, Ministry of Finance. To stop. The brief facts of the case are that the central government has issued a notification dated 6/9/2018 while exercising powers under subsection 4 of section 1 of Recovery of Debts Due and Bank Financial Institutions Act 1993, whereby it is specified that the above act shall only apply where the amount of debt due to any bank or financial institutions or to a consortium, bank or financial institution is less than 20,000. Full stop. The notification dated 6/9/2018 put to challenge before the Rajasthan High Court in a writ petition, and the effect and operation of the said notification was stayed on 26/9/2018. Para. In view of the stay granted by the Rajasthan High Court by the order dated 26/9/2018. A question arose, what would happen to those cases which were filed during the period of 26/9/2018 and 30th of June 2019, wherein the amount involved is less than rupees 20 lakhs. Full stop. Facing with this such situation, we this 1/8/2019 communication was issued by whom?
By the, your lordship, Deputy Secretary to Government.
Deputy Secretary, your lordship.
Facing with the such situation, the Deputy Secretary of the
Of the, your lordship,
Government of
Government
India.
of India,
Government of India, Ministry of Finance.
Finance. Your lordship.
It should be, there is nothing there, but it should be.
Finance.
Issued and communication dated 1/8/2019. Whereby it was clarified that the cases पहले एक बार थोड़ा सा लास्ट में फेसिंग विद द सिचुएशन से पहले बताना व्हाट $20 lakhs. Full stop. No, in the meantime, facing, it is to be noticed that the stay granted by the Rajasthan High Court was vacated with the dismissal of the writ petition on 1/7/2019. However, who are facing with the situation that what would happen to those cases which was filed during the currency of the stay petition, wherein the amount is less than 20 lakhs. The Deputy Secretary to the Government of India, Ministry of Finance, has issued an communication dated 1/8/2019 stipulating that the cases having suit value between 10 lakh to 20,000, which has been filed before the debt recovery tribunal, may continue in DRT till conclusion, so that no prejudice shall be caused to the parties who have filed the suits in good faith. The petitioners have challenged the impugned, the challenge the said communication dated 1/8/2019 on the ground that the cases filed during the interim period before the debt recovery tribunal cannot be tried by the debt recovery tribunal, as the said communication has no force of law. The learned single judge, after taking into consideration the observation, taking into consideration the arguments advanced on behalf of the parties, respective parties, have disposed of the writ petition with the following observation. In para number, completing para number, these are 1, 2, 4. It is also to be noticed that though the appellants have filed this writ appeal in the month of
Was
when you have filed this appeal. 6th of October 2020. In the month of October 2023. But subsequently, Ministry of Finance has issued a notification dated 25th of April 2024 in exercise of powers conferred by subsection 4 of section 1 of the Recovery of Debts and Bankruptcy Act 1993, whereby the whereby the notification dated 6/9/2018 is amended. The notification dated 25th of April 2024 is reproduced here under page number 127. From the above, it is clear that pursuant to the liberty granted by the learned single judge in the impugned judgment dated 31st of August 2023, the respondent number 3 has issued a notification under section 1 in bracket 4 of Recovery of Debts and Bankruptcy Act 1993, saving those cases filed during the period from 28/9/2018 to 30th of June 2019, comma, when the stay order passed by the Rajasthan High Court was in currency, comma, whose suit value was below 20 lakhs before the debt recovery tribunal is stopped. In view of the above, we are of the view that the application, original application number 97/2019, referred on behalf of the appellants, is liable to be tried by the debt recovery tribunal concerned. Hence, the observations, hence the directions number 3 and 4, Roman 3 and 4, passed by the learned single judge are not required to be given effect to. With these observations, this writ appeal is bestowed.
Deeply.
He also disposed. These observations are here as well as the writ appeal.
Item number 4.
Item number 4, my lord, I have filed one rejoinder affidavit. It
No
may come
reply,
to,
applicant has been received.
it may come to the record. I have filed one rejoinder affidavit, it may come to the record. Copy shall,
You have filed,
yes, ma'am.
when?
My lord, today morning, yesterday I give my clap, today morning, yes, filed. Copy
And
shall,
answer for the petitioner has submitted that he has already filed counter. to the reply filed on behalf of the respondent number 124. This case for admission after 3 weeks.
Item number 5.
Now, in this matter, my lord, we have taken fresh steps by paper publication Lord, and file affidavit to that effect. My lord. Well, I am appearing for private respondent. Extra copies are with me.
Where is that?
Lord, the affidavit, my lord, we have filed on, my lord,
You are
7th of,
appearing for all the respondents.
my lord, I will appear all the respondent, although file Dukalam for some of them.
The service of notice upon the respondents through paper publication is affected and an affidavit is filed on behalf of is affected as per the direction given by this court on 22nd of May 2024. And an affidavit of this effect is also filed on behalf of the petitioners, on behalf of the Mr. So is appearing on behalf of all the respondents.
Yes, my lord.
All the respondents, service is therefore complete. This petition for admission after 3 weeks.
My lord, can a date be fixed, my lord? Because, my lord, before the learned Central Administrative Tribunal, my lord, my lord, I pray on 5th for affidavit. My lord, 5th of August, my lord. Private respondent, I'll file affidavit.
File an affidavit, we have granted
4 weeks.
3 weeks, 4 weeks time. 4 weeks के बाद की date.
My lord, will fix it on 5th of August, my lord, because there is an order passed before the learned Administrative Tribunal. Contempt petition is filed, my lord. And
Sure, it's at least we have to grant him time. 5th of August is just approaching. Weeks के बाद की date. Yes,
because the coercive orders would be passed, my lord, that is.
you mentioned this that your appeal is already granted time to file the flag. In the writ petition. Yes.
21st August. Item 7.
Yes, Mr. Madhu.
There was a slight mistake. The orders were passed then itself, but for some reason it was not issued. Therefore, he did not get it. I've got the issued letter now. What happened is the director had taken the decision, but the file, instead of sending the order copy to him, skipped aside. Now it is now today evening he should get the issued order. I've told him I'll give him a copy myself.
Yeah.
The moment I have it.
This contempt petition is filed by the petitioner raising a grievance that despite direction given by the learned single judge as well as the division bench of this court, the representation filed by the appellant, by the petitioner has not been decided by the authorities concerned despite passing of a considerably long, despite passing of a long time. So, Mr. Majumdar, appearing for the education department, has informed this court that as a matter of fact, the representation of the petitioner has already been decided, but unfortunately, the decision has not been communicated to the petitioner. He assured this court that the decision on the representation of the petitioner would be communicated to the petitioner within a period of
By Monday. I should have it by today. If I have it today evening, I can give it to him, or by Monday at least.
2 days through his concept.
Okay.
So in view of the above, no further order is required to pass in this contempt petition. The same is disposed.
Item 8.
Delay condonation, 31 days, neither AD card received nor notice in respect of respondent number 1, 3 and 8. Yes, you are.
I'm for the respondent number 2, my lord.
Respondent number 2.
Yes.
Will await the return of. Await earlier also we have awaited either take fresh steps.
Please step.
The notice issued to the respondent number 1, 3 and 8 has not been served. till date. Let fresh steps be initiated for service of notice upon the respondent number 13 and 8. Requisites be filed within a period of 1 week. On filing of the same, let notices be issued to the respondent number 138 through registered date and returnable.
Much, sir. All right.
3 weeks. 3 weeks later.
Item 9.
Your Lordship, this is a condemnation of delay application by the state as per office note dated 17/7/2024.
300 and
Services incomplete, my lord. Upon
so
respondent
what is
number
the
1.
reason for that? The notice have already been issued.
Yes, my lord, service is incomplete upon respondent number 1.
Respondent number 4 has not been served till date.
Yes, my lord.
Earlier also the notices were awaited. Take fresh steps. As per the office report, notice issued to the respondent number 4 has not been received till date. Let fresh notice be issued to the respondent number 4. Steps be, requisite steps be taken within a period of 1 week on taking same. The notices be issued to the respondent number returnable 4 weeks.
Obliged.
Yes. Registered AD. written.
Item number 10.
Lordship, this is an interlocutory application for
Respondent number
condonation of
4
guilt.
and 4 and 5 have
Lordship
not
has not
served till
been-
date.
No, it was served. AD card has not been received back.
Who is appealing for them, sir?
As of yet, nobody has appeared, my lord, college, my lord.
So from where we get this, that the notices have been served?
164, 145. Lordship, it's not on record. Lordship, but I am told by my client, but Lordship, unless they appear before this honorable court. Lordship, there is no proof as such. So,
Furnish some proof. When,
My lord.
Get read the service of notice upon the respondent.
My lord.
Is complete.
My lord.
We'll await the return of the notices for 1 more week.
My
In the meantime,
Lordship,
await return of notices of the respondent number 4 and 5 for 1 more week.
obliged.
Item 11.
Ten days delay. Who is
My lord,
appealing for
it's a
the-
delay, but matter is same as your lordship has already disposed similar matter, my lord.
Which one?
That writ appeal number 203/24 on 21/6/24, that appeal has been filed before the session court, my lord, sorry, district judge from state officer, from order of the state officer of railway. We have filed
You
an
have the copy of that, judge.
copy. I don't have number, just now I have received.
Number?
21?
Yeah, writ appeal number 203/24. And order is on 21/6/24. Same matter, same matter, madam, because your lordship was pleased to dismiss that case matter. Yeah.
Dispose it of in terms of.
Yes, same.
And concept of the. applicant has frankly submitted that. In identical case, this court has already dismissed the writ appeal. Wide writ appeal number 203/2024 by the order dated 21/6/2024. Wherein the order passed by the learned single judge on 6/5/2024 passed in writ petition number 86/24 was under challenge. And counsel has submitted that the challenge made by the applicant to the impugned judgment of the learned single judge in the connected writ appeal is identical. In view of the submission made by the learned counsel for the applicant, this IA number 1508/2024 and the writ appeal number 4947/2024, which is yet to be registered of this case.
Item 12.
Lordship, I'm appearing for V. Valangthasa, IA Civil 1946 of 2024.
Explain the delay of 584 days.
Sir, your lordship, the appellant was from Aizawl and she has contacted the advocate, but the advocate was not there. And the appellant was not aware of the dismissal of the prosecution.
What happened in that recall application?
Yeah, we have filed this restoration and then delay condonation also.
Restoration, the writ appeal was dismissed.
Yes, sir. Yes, your lordship. The delay happened because the appellant was not aware of the status of the case. And they tried to contact the advocate, but the advocate didn't contacted them back. That's why this delay happened. And as soon as the appellant came to know about the delay, they immediately filed this condonation and then the writ also.
Do, man. By the appellant challenge the common order record reveals that many occasions no one has appeared for the appellant. What else?
They tried to contact them, the advocate, but the appellant was not aware. So as soon as they became aware of the fact, they filed it. And it was in Aizawl, Mizoram, and then they have engaged counsel in Guwahati, and the counsel was not in contact with them.
Earlier, who was engaged? Advocate from Guwahati or Aizawl?
At first it was from Aizawl, then they engaged someone from Guwahati, and then he was also not into that matter. So they engaged the recent counsel, the new engaged counsel here.
And the writ appeal, in writ appeal, who was engaged as a counsel?
Your lordship, I am not much aware of the fact as actually my counsel, he is out of station, and then his father has cardiac arrest, so he couldn't attend today. So I was sent immediately. So I know the mere facts about the case and then not the previous one.
Notice. We should
Sir,
come prepared.
notice should be issued, your lordship.
Notice returnable 6 weeks. You should come prepared, madam.
Definitely, lordship, next time.
Item 13.
Highly obliged.
Well, this is an IA for condonation of delay of 69 days lordship in preparing the connected reject appeal lordship. My lord, I have stated in paragraph 3 in my petition, the reason of delay lordship. Page 4, para 3 lordship. Matter is pertaining to selection and appointment of principal of a high school. And I was appointed, but subsequently in the petition lordship, the learned single just set aside the order of appointment.
When you have applied for certified copy,
My lord, of 24/6, 2020.
why? When the judgment was passed in
21
April, no, in May, why you have applied for this? And now you are blaming the court that
My
the order was not uploaded. What do you mean by uploaded?
My lord,
And
that
once
was the-
it was pronounced in the court,
My lord,
you have to apply very same day or the next
yes,
day.
absolutely, lordship.
Then
Their
how
fault,
can you
lordship,
blame the
that,
court for that?
their fault, lordship, was committed by the applicant, lordship, because he could have applied for on that day, lordship. That was not done, lordship. He was expected that he, the order will come in his favor.
And
That's-
how you are agreed by this order?
My lord, that order of my promotion to the post of principal has set aside by the learned single judge.
It was rightly set aside. You were not having that qualification and you were promoted.
My lord, I was qualification of Hindi lordship in Porangor, which is
That was later on recognized, not on the date when your promotion was granted to you.
my lord, what happened, lordship? The selection, lordship, that
Notice returnable 6 weeks.
my lord.
Yes, what do you want?
My lord,
So we have issued the notice.
my lord, obliged, lordship. Sorry, lordship.
Item 14.
May I have the lordship? Lordship, this is a appeal by the state, my lord, assailing an order passed in WPC number 14, my lord, assailing an order dated by 23/2/23. The respondent, my lord, as a delinquent at the office of the excise department, my lord, he was issued a show cause. And the, my lord, inquiry officer reported that the charges are vague. We have to frame specific charges, my lord. So on that ground, my lord, additional show cause was issued, my lord. The learned single judge constituted it to be a fresh notice, and my lord just set aside, my lord. I will find the judgment at the judgment at page number 102. And my lord, the provision to put earlier.
Where is the second show cause notice?
My lord, it's page number 86, my lord. It's not, it is additional, man. The first paragraph shows these charges are framed in addition to the charge framed.
Where is the first show cause notice?
Page 61. 61, my lord.
Yes, Mr. Das.
My lord, if your lordship kindly see the affidavit filed by the state at page 95.
That has been quoted by the.
Yes, and page 98. 98, last line, that the deponent begs to state at page 98.
Yes.
That the deponent begs to state that the state inquiry officer requested a department to frame the charges properly, and therefore a fresh so-called notice is issued to the petition. No, my lord.
They show cause notice says addition into the charges others.
No,
Even
now
though if
the,
they have said they, how?
no, now my lord will kindly see the first so-called notice was issued
Yeah.
at page 61.
Yeah.
And a reply which was filed by us at page 71. And the document at page 70. Kindly see at page 70,
Yeah,
71.
yeah,
71 is my reply.
yeah.
And the list of documents at page 70. What was I saying? At page 56, the 86, the second so-called start, my lord.
Yeah,
86 and see at page 91.
yeah.
List of document.
Yeah.
So-called reply received from C so and so, relying on my so-called reply.
and two is earlier
How
so-called
you are
dated.
prejudiced, sir? How
Kindly,
you are prejudiced?
I will be prejudiced.
Inquiry was not at all initiated. Inquiry officer was appointed and he simply said, "Okay, frame the charges."
Enquiry officer, my lord,
Definite.
enquiry officer doesn't have the power also. Well, I'll show my lord the power.
It can very well ask for the clarity. On
No, he's, my lord, see the power section, my lord, where is that power? My lord will kindly see at page 106.
Yes.
Kindly see
So
106.
you mean to say that whatever the charge is, the inquiry officer has to look into that without taking into consideration the what are the
But
charges and how can it be proved?
Kindly see, no, we are going by provision of the provision of the act. Kindly see the provision of the act at page 107.
Yes,
Please see 107.
yes.
The procedure for imposing penalty 9(6) kindly see man at page 107.
Yes.
The enquiry authority shall in the course of the enquiry. Lordship got it? Page 107.
Yeah, that they have quoted.
The enquiry of the authority shall in the course of the enquiry consider such documentary evidence and take such oral evidence as may be relevant or material in regard to the charges. The government servant shall be entitled to cross-examine, witness, examine in support of charges, and to give evidence in person and to adduce documentary and oral evidence in his defense. The person presenting the case in support of charges shall be entitled to cross-examine the government servant and the witness to examine his defense. If the enquiry authority decline to examine any witness or to admit any document in evidence on the ground that his evidence or such document is not relevant or material, it shall record it in writing. At the conclusion of the enquiry, what the enquiry officer could have been done, if the first enquiry he could have proceeded on the basis of my reply, then only he can, my lord, issue the fresh so-called notice or an addition. He cannot do it because of 7, 6, and 7. Kindly see 7, my lord. Kindly. And where is that in my reply? He is relying on my reply and a list of documents. Kindly see 7, my lord. He can, of course, my lord, I agree. I agree to your lordship. But when he can do it, my lord? Kindly see 96, the Assam Discipline Appeal Rules. 9, the procedure has been laid down, my lord. Assam Discipline Appeal Rules, my lord. See the procedure, my lord. 9. 96, 9 and 6 and 7, is it? My lord, kindly see 5. If you lord. Yes, sir. Sorry. First, I like to stress on the affidavit that has been filed by the state. No, my lord, that's your lordship may negate my contention, but kindly see, but that's my argument.
Yeah.
They have sworn, my lord. They cannot
On
say now.
affidavit, They said that it's a new show
Correct,
cause notice
right.
and not an additional.
Absolutely.
That's all.
That's all, my lord. That's your lordship will
Yeah.
kindly note it. Secondly, my lord will kindly see the Assam Dismissal Appeal rules.
Yes.
I like to place it. Kindly see 5,
Yes.
9(5).
Yeah, fine.
Procedure for imposing penalty, then 5 kindly see, my lord.
Fine.
Disciplinary authority may nominate any person to present the case in support of charges before the authority inquiring into the charges.
Fine.
So when the first so-called notice was issued at page 61, a reply was filed by us and accordingly inquiry officer was appointed. Now, my lord will kindly see the government servant may present his case with the assistance of any other government servant approved by disciplinary authority, but may not engage a legal practice so and so. Now, the first so-cause which was issued to us, we file a reply. There has to be a logical conclusion which was not done. Now, what they have done, now a so-called notice has been issued. Relying on my reply which has been filed. See, kindly see at page 91, list of documents, my reply which has been filed. Now, what it says, once the inquiry has started on the basis of the first so-cause.
In fact, the inquiry is not even started.
That's what I'm saying.
Not begun.
No, that's what I'm saying.
The documents were referred to the inquiry officer and we said, "Okay, see, look, these charges are not sufficient or not properly explained. You frame another charges and send it."
No, where is that, my lord? Why I'm saying under what provision he say he can place it before the.
Sir, where is the bar?
No, there has
The
to.
inquiry officer even can punish a person for a charge which was not there in the original charge sheet.
That's what, my lord. What?
Explanation says clearly, sir.
No,
It is
kindly.
a wide power.
No, kindly see 6, my lord. The
Six, yes.
inquiry authority tell in the course of the inquiry, consider, my lord, what the inquiry officer should have been done in this particular case. My lord, the first so-cause reply file, thereafter the inquiry would have been started.
Sir, still, it is only a show cause.
Show cause, my lord.
And nothing else.
Yes.
Only a show cause.
But that,
Again, the inquiry officer will submit your reply. Again, the inquiry officer will consider and ponder over it, and then only he will initiate the
My lord.
inquiry.
but my lord will kindly see.
And even it is still the chance is there that the disciplinary authority may drop the inquiry.
No, but where, my
After
lord,
filing your fresh show cause
My-
notice,
my
they can
whole-
very well drop the inquiry.
my whole case is based on the, kindly see the explanation also, my lord.
Yes,
My kindly see the 7 explanation. See the 7 explanation.
yes.
At the conclusion of the inquiry, the inquiry authority shall prepare a report of the inquiry recording its finding on each of the charts together with reason thereof. See the explanation. If the opinion of the inquiry authority, proceeding of the inquiry, establish any article of the charts different from the original article, it may record his finding on such article of it. He has the power. We are not saying that he doesn't have the
The
power.
only thing is that since this, the procedure laid down under Rule 9, now
Yes.
the stage reached up to
He
four.
could, yes.
Sub-rule 4. Sub-rule 4, the moment the document was submitted or sent to the inquiry officer, you opine that these charges are not sufficient or not properly explained. You please issue, frame additional charges or clarify them. Now they have clarified it and again
That's
given you a chance that you submit your show cause. Again, the procedure under Rule 4 has to be followed then.
no, when he realized,
He realized immediately.
No,
when the
he
report was
realized,
Sent to him.
no, he realized when I file a reply, then he realized. Then he realized.
Reply, you filed reply prior.
What, my greatest, my lord,
You filed reply in advance. And thereafter the matter was referred to the inquiry officer where the disciplinary authority has decided to appoint an inquiry officer.
no reply.
You filed a reply before the disciplinary authority, not before the inquiry officer.
No, absolutely correct. An inquiry, my lord, we have to file it before the disciplinary authority. Rule says, then my lord, inquiry officer will be appointed. Once the inquiry officer is appointed, he will only look into my reply. He will not say, no. Issue a fresh notice. Where is that power, my lord, which is under that, under which?
Where is the prohibition?
Which is that, my lord?
Where is the prohibition?
No, my lord, that has been prohibited. 1 second. I am just giving a query. But where is that, my lord? I am asking myself with greatest respect to your lordship. Where is beyond the power? There has to be some power. My lord, there has.
Open if a person is.
I'm sorry to say.
If a person is given a task to bring a matter to a logical conclusion. He has to have all the records and clarity.
My lord, logic with.
And that's what he is.
My lord, my
he has,
greatest.
he has referred the matter. Please
My lord,
the charges.
my
The charges are
respectful,
not clear.
my respectful submission, with greatest respect, I am saying, my lord, only to the extent he can exercise his power under the Assam Disciplinary Appeal Rule. He cannot go beyond that. My lord, how, my lord, my reply, once I give my reply, then he's saying that no.
He is not inquiry officer.
No, I'm sorry. No, I am right. When it went to the disciplinary authority,
Next one is addition to the.
When you have filed the.
I'm sorry,
The show cause, reply to the show cause?
my reply to SOCOS.
Yeah.
Yes, I am telling you, lordship. My reply to the SOCOS is 71. My lord. Date. 22. 18.
22/4/18.
Yes.
And when the inquiry officer has returned the record?
I'm sorry, my lord. Record.
Yeah.
Data didn't record. Let's see.
13 April 2018.
So.
And also,
But after that, you have filed the reply. How you can say that the inquiry officer has used my reply? That is there.
well, my contention is very simple.
See
That
page
this-
91.
Show cause, go there. I delight the
please-
judgment also, my lord.
1 second.
Well.
See, my lord is asking me something.
Well.
Sir, please see page 91.
Yeah.
This is date he has given, list of documents, kindly see. It was with him, list of documents. So-called reply received from so-and-so DSC on 22/4/2018 at page 91. This is what we have challenged, my lord. This is what we have challenged. Kindly see at page 91. One, so-called reply received from so-and-so dated 22/4/2018. Earlier so-called notice dated 18/8/2017. How can the earlier so-cause be a part of the second so-cause?
Yes. File your counter.
I'll file it. I'll
File your counter.
My lord, only difficulty,
Operation of the order.
my lord, the only difficulty.
Yeah.
My lord, only difficulty with great respect, my lord, the promotion is the problem. That's why some promotion is withheld because they file an appeal.
Sir, still, even though if by going by this first show cause notice, they can proceed. Your challenge is up to
No, no, what
this
my lord,
second show cause
absolutely,
notice.
my lord, my
So
only,
in any case, the promotion is to be withheld till the
No, no.
conclusion of the inquiry.
no, that's what, my lord, if the first so cause they could have proceeded, no problem, absolutely.
No
What
problem,
our
because
whole
there is no
case,
clarity in that.
there is no, my lord, that's what our case is, my lord.
Look here.
My lord, only one humble submission is 3 weeks' time we'll file it. And if there is no, we'll file, my lord, within 3 weeks. And thereafter, the matter may kindly be listed.
Well, yes, certainly, look here. This, writ appeal is filed, this writ appeal is filed by the appellant being issued with the order dated 2023 passed by the learned single judge in writ petition number 3529/2019, whereby the learned single judge has set aside the impugned show cause notice dated 25/1/2019 issued by the appellants to the.
Well, I'm sorry for the disturbing your lordship. We'll give a reply to this, my lord. To the grounds of the appeal. Your lordship is taking up the matter after 3 weeks. In the meantime, we'll file an objection to this. Yes, yes, that's why. Yes, sir.
Whatever objection reply you want.
Yes, yes, we'll file it.
क्या लिखा है? Appellants, while observing that the same is the second show cause notice and the disciplinary authority has no power under the Assam Service, the Assam Services in bracket Discipline and Appeal Rules 1964 to issue a second show cause notice. So when it comes to the appellant has pointed out that the show cause notice dated 25/1/2019 is not a fresh show cause notice, and it is only a notice in addition to the earlier show cause notice dated 18/8/2017. It is submitted that the letter dated, it is submitted that the show cause notice dated 25th of January 2019 clarifies that the charges communicated to the private respondent are in addition to the earlier charges framed by the letter dated 18th of August 2017. It is also submitted by the learned counsel for the appellant that by issuance of the show cause notice, impugned show cause notice dated 25/1/2019, the petitioner has not been prejudiced, the private respondent has not been prejudiced in any manner, and he has failed to satisfy the court that and he has failed to demonstrate that he is prejudiced by issuance of the said show cause notice. Stop. learned concept of the private respondent has vehemently opposed the writ appeal and has argued that under the provisions of the Assam Services in bracket discipline and appeal in bracket close rules 1954, the disciplinary authority has no power to issue a show cause notice, a fresh show cause notice. It is also submitted that under the said provisions, the inquiry officer has also no power to ask or request for framing of additional framing of new charges of issuance of fresh show cause notice. It is therefore submitted that the learned single judge has rightly passed the impugned order. Having heard the learned concept of the parties, and after going through the impugned judgment as well as the material available on the court, we are of the view that the matter requires consideration. Hence, admit in the meantime, effect and operation of the impugned order dated so and so passed by the learned single judge shall remain stay. The private respondent may file counter affidavit or objection, counter affidavit / objection within a period of 3 weeks, list after 3 weeks.
All right. Reply of.
Item 16.
That compassionate appointment.
Compassionate appointment matter, my lord. Already lordship has admitted the other appeal. My
Appellant has submitted that identical things have already been admitted by this court.
appeal to number.
Hence, admit no need to issue notice as parties, as the sole respondent is intended. Okay. List this writ appeal along with writ appeal number 50/24.
Item 20.
May I please, your lordship?
Yes.
As per High Court rules related to PIL, your lordship.
Yeah.
In the clause F, in the last portion, if the petitioner is an organization, the names and address of its office bearer and the nature of its activities shall also be stated.
Yeah.
But your lordship, in my petition, it was not stated, your lordship. And the another is, your lordship, there is a Supreme Court guidelines, your lordship. It is in the Supreme Court guideline, it is a notification, your lordship, dated 1/12/1998. In this notification, your lordship, the last time says cases falling under the following categories will not be entertained as public interest litigation, and this may be returned to the petitioners or filed in the PIL cell as the case may be.
1998, after 1998, much water has flown. Sir.
Lordship?
After 1998, much water has flown.
Uh,
The rules are there.
Yes, lordship. And the Supreme Court guidelines also, you also in case of public interest litigation, it is also appendix 35 in the High Court rules, your lordship.
Yeah.
This matter is exception, admission to medical and other educational institution.
Yes.
So my matter also in this category. So your lordship, I may be allowed to return the PIL and a highly appropriate form.
The net concept of the petitioner in person has frankly admitted that the public interest petition filed by him comes within the exception as provided under notification dated 1/12/1988 issued by the Honorable Supreme Court of India, comma, appended to Appendix 35 of the Guwahati High Court rules. He is therefore prayed that he may be allowed to, that the brief filed by him be directed to be returned to him with liberty to the petitioner to approach the appropriate forum in view of the said submission made by the petitioner. This PIL petition is closed. The brief filed by the registry is directed to return the brief to the appellant, to the petitioner. And the petitioner shall be at liberty to approach the appropriate forum for redressal of his grievance.
Item 21 and 22.
Here the issue was regarding.
Promotion.
Well, it has been sent before the cabinet, just given the instructions I received.
So when you are going to take a decision?
The cabinet has to approve it prior to our
So when is the cabinet is going to approve it?
cabinet. I cannot say, but plus will give me 4 weeks.
4 weeks, cabinet, as per the newspaper, the cabinet, met yesterday only.
My lord, we have sent it by, we have sent for all the views through the e-cabinet proposal, my lord, I have given that. It is only when the
That was
cabinet,
considered or not?
my lord, it was not considered, it was not considered yesterday. Views of one department remains, my lord, what I am told. To the paper.
Yes, mister. Grant them sometime.
Lordship, may I kindly fix a date?
Okay. Mr. Al-Mujumdar has submitted that. The.
Yeah.
The matter is pending with the cabinet of with the cabinet and is likely to be taken up by the cabinet in the next meeting, in its next meeting. He plays 4 weeks time. This conference should be in 4 weeks time. Get it approved, sir. Once you have principally decided, then get it approved.
21-8.
Much obliged.
Item 25.
May I please have a look? In this matter, my lord, government has not filed their affidavit. Lordship. Education department is also part of it.
Who is going to file the affidavit?
My lord, SC elementary and my lord, government of Assam, Lordship.
So even though if they file affidavit admitting your claim, then also
My lord.
what remains?
Copy one.
Well, memo of appeal is yet to be served on us. Memo of appeal is yet to be served.
Please be. Yes.
My lord, the matter relates to compassionate appointment, Lord.
Very good.
My lord, my lord, petitioner's father died on 27/9/2009, Lordship.
Fine.
And
Delay.
delay. And he applied on 25/2017, Lordship. For 8 years, Lordship.
Oh.
So, Lordship, my case was not placed before the DLC, Lordship.
How can it be considered after 8 years?
My lord, 8 years.
Why you applied so early? Would have applied in the year, this year only, because the government is bound to give you the appointment. Anytime you can go and approach the government, say, okay, my father died on so and so day. So give me the appointment.
My lord,
In fact, it's a very bad case, Lordship. I agree, Lordship. But, Lordship, our one High Court judgment, Lordship, says, Lordship.
But why you have filed this appeal? Even though you have tried that before the learned single judge also you have tried.
My lord.
But
My lord, I leave it to your Lordship. I leave it to your Lordship.
writ appeal is filed, this writ appeal is filed by the appellant being agreed with the order dated 2/6/2023 passed by the learned single judge in writ petition number 3145/2023, whereby the writ petition filed by the appellant seeking compassionate appointment has been dismissed by the learned single judge on the ground that the appellant has approached the authorities concerned seeking compassionate appointment with a great delay. Full stop. The learned single judge has taken into consideration that the father of the petitioner, who was serving as head teacher with the government, died in harness on 27/9/2009. However, the appellant has moved application seeking compassionate appointment only on only in the year 2017, that is after long delay of 8 years. And therefore, long delay of 8 years. After observing this, learned single judge has held that the objective of a scheme of compassionate appointment is to grant immediate leave to the family concerned. And therefore, the 8 years delay on the part of the appellant in approaching the respondents for compassionate appointment is not in consonance with the scheme. Hence, no interference is called for. Stop. Learned counsel for the appellant after arguing the matter for some time has failed to persuade us to take a different view as has been taken by the learned single judge. Hence, no merit in this appeal. Dismissed.
Highly appraised.
Item 29.
May I please the Lordship?
Yes,
Matter relating to pensionary benefit,
family
Lordship.
pension.
Yes, Lordship.
What is the proof that you are married to her and what is the proof with the railways?
Lordship, nothing is it.
So simply place it on record to whomso it is concerned. Gaon Pradhan. Gaon Pradhan, what is the
Or
authority?
Deputy Commissioner also issue a Lordship.
Huh?
Deputy Commissioner also issue a next scene of certificate, Lordship.
Well, that, when you got married
Lordship, 1984, Lordship.
and when his first wife was
Alive.
died,
Alive.
alive, still alive,
Alive.
Now died.
now dead.
Now died.
First wife
Now
already,
she is claiming.
first wife had already been died, Lordship.
Now she is claiming. At that point of time, she never raised one. Now she is.
And when you solved this second marriage, when the first wife was alive, how that marriage itself is legal?
Actually, it is as per Hindu Marriage Act, Section 11 is a void, Lordship.
Then
As per various judgment also, as per Lordship, Railway Pension Act, Central Civil Service Pension Rules 54, Sub-Rule 7 is also, he is entitled, Lordship.
he is
The petitioner is entitled, Lordship.
Subject to that, is she?
Petitioner is entitled.
Entitled.
Yes, Lordship.
Until and unless that marriage is valid. That marriage is void.
Another act is also Lordship, the Railway Service Pension Act 1992 as amended. Rule 75 is also in the instant petition is entitled.
If
Lordship.
a lady not legally wedded, she is also entitled for family pension.
Lordship, as per various judgment of the Bombay High Court and Karnataka High Court is not violated the
Then it's better you approach the Bombay High Court.
Lordship.
You will not get the order. How can it be? There are so many questions you have to answer. Whether your this Gaon Pradhan certificate,
Lordship.
Token certificate,
Lordship.
on what basis it has been issued,
Lordship.
whether that marriage with the deceased was legal or not.
Lordship.
How can it be? Yeah, this petition is filed by the appellant, by the petitioner being agreed with the judgment dated judgment dated
30 May.
with the order dated 30th of May 2023 passed by the Central Administrative Tribunal Guwahati bench hereinafter to be referred as CAT in OA number 129/2023, whereby the OA filed by the petitioner seeking compassionate appointment with the railways, with the Department of Railways has been dismissed. Sorry, family, whereby the application filed by the petitioner seeking a direction to the railways, the respondent railways to grant her family pension has been dismissed. Full stop. The tribunal has come to the conclusion that the petitioner has failed to substantiate her claim, failed to substantiate that the name of her was recorded in the service book as wife of the deceased employee. It is further observed that the first wife or legally wedded wife of the deceased employee has already received family pension and family pension. The CAT has further observed that the identity of the petitioner as wife of the deceased employee is not reflected in the service book of him. While observing this, the tribunal has dismissed the OA filed by the appellant, filed by the petitioner. Having heard the learned counsel for the petitioner after going through the material available on our record, we don't find any illegality in the impute order passed by the CAT as the appellant has failed to satisfy, as the petitioner has failed to furnish any proof that she is the legally wedded wife of the deceased employee.
Item 30.
Lordship may grant us 2 weeks further time, Lordship, to file our response, Lordship.
Mr. Chakravarti, enough time was granted.
Lordship, earlier time was granted, Lordship. I have received the parawise comments, Lordship.
Mr. Chakravarti, please, take some more time to reply to.
Interim order may be continued, Lord.
Interim order, what interim order is there?
Lordship. No. My lord, no additional post to be filled up. That was the order. But that order was not till the next date when it was granted on the initial date when notice was issued. But thereafter, Lordship, it was continued day after day, Lordship. Actually, it was absolutely granted on the initial day.
In the interim, the respondent personal policy shall not fit any post of author, appointing the selected last made of. Oh, that's a good order. Your name was not in the select list.
In the wet list also.
And nothing else. File in vacation for this.
No,
And,
the last-
Security grace for more time to file reply to the state petition for time paid for is granted. Let's conference so 3 weeks. Ka time. In the interim order to continue.
Obliged.
16A.
Item 32.
May please, your lordship. My lord, in this case, my lord, as per the order, previous order, I am to argue on the maintainability as a PIL. My lord, matter relates to a school, my lord, of Silchar College School in the district of Kasar. My lord, my only point is that when some teachers involved with the molestation of students, girl students of the school, my lord, when some teachers involved in the, my lord, NEET examination scandal held in the school. My lord,
NEET examination.
NEET examination scandal
When?
in 2021, my lord, of course, my lord. And there are some other allegations against some of the people who are involved, connected with the managing affairs of the school and teachers also. My lord, the previous committee, managing committee has taken some action against those people. By the impugned order,
This committee was appointed by whom?
my lord, committee, my lord, as per the 2006 Act, it should be, my lord, there is some guideline for formation of student, my lord, managing committee. But by the impugned order, Annexure 8, page 53, the deputy commissioner has cancelled all the decision, resolution taken by the previous committee. And thereby, our concern is that thereby the people who are the teachers who are involved with the molestation of girl students and other anomalies, my lord, they are given clean sheet, my lord. We are not concerned with the constitution, reconstitution of the managing committee. Whether we are not concerned whether the guardian society are inducted, a representative of guardian society are inducted in the committee or not. We are not concerned on that, man. Our only concern is that the managing, my lord, the people who are involved with the serious allegation and previous committee has taken some action against them. And those decisions, those, my lord, resolution are totally cancelled, and even the committee has been.
Yes, you are appearing for whom, Mister? And other respondents?
Yeah,
You are for these 1 and 2.
1 and 2.
What about this 3, 4, 5, 6, 7?
My lord, I have instructions to appear for respondent number 7, though I have not received the file by.
Only respondent number 7.
Only respondent.
Yeah,
number
Inspector
seven.
of Schools, Mister, you will appear for this.
Madam, yes, Inspector, I'll appear.
Lease,
I have received.
Commissioner, Secretary, Director, Secondary Education,
I have.
Deputy Commissioner Kachar, District Commissioner Kachar, Madam is appearing, and this ACS Executive Magistrate, Himashri Deka, ACS Executive Magistrate Kachar,
That is by name, it has to
Go by post, my lord.
go by.
and Principal Silchar College.
That also, my lord, go by.
Huh?
Prince, I
It's
have.
a private school, so it has to be.
Inspector of Schools, you will appear.
I'll appear.
Like,
The only thing is,
I have only one submission.
yeah.
Lordship, actually, the constitution itself of the guardian committee is being challenged in a suit by a set of guardian. I have the plaint and the injunction petition with me. The purpose of this PIL is only to frustrate and not means allow the trial court to pass the injunction.
Lordship.
My lord,
Except
we are
the
not concerned with the
Constitution.
constitution, the constitution.
A set of guardian.
Set of guardians.
I have the plaint with me, Lordship, the Constitution of the Guardian Society.
Collegiate Teachers and Staff Association.
Yes, Lordship, but they have instructed me that there is a suit pending before the Civil Judge Junior Division number 1, being titled suit number 212 of 2023, where a set of guardian, they have filed this suit to challenge the Constitution of the Guardian Society. And they have, there is an injunction petition also pending there. Just to frustrate and to means any notice of motion,
To frustrate the injunction petition or what to frustrate?
the injunction petition, Lordship.
Injunction petition, you are in favor of that injunction, grant of injunction?
Lordship, I have the instruction to
You are the
simply place.
association, how you are
Lordship.
with the suit if some guardians have filed?
I have the instruction to place it before your Lordship,
Oh, that's right.
because any notice
Listen,
of
but
motion,
At least we should understand how it is relevant for that.
because any issue of notice
Okay,
will.
let us see. Though this court wide order dated 14/6/2024 and 27/6/2024 granted time to the counsel for the petitioner to satisfy regarding the maintainability of the PIL petition. We deem it appropriate to grant opportunity to the respective respondents to file their response to the writ petition. Including the objection regarding the maintainability of the writ petition. Mr. Majumdar put in appearance on behalf of the respondent number 1, 2, and 6. 1, 2, and 6. Madam Bora is appearing on behalf of the respondent number 2 and 3. Only 3. On behalf of the respondent number 3, let notice be issued to the respondent number 4. The respondent number 3, Madam so and so is appearing on behalf of the respondent number 4.
7.
The 7. Let notices be issued to the respondent number 4 and 5, returnable on 12th of August, 2024. Dusty, registered AD, through Dusty and registered AD both.
My lord,
Registered AD and Dusty
yes,
both.
my lord,
Registered AD and Dusty both. The question regarding the maintainability of this PIL is kept open and will be considered after receiving the reply from counter to the writ petition from the respective respondents.
deeply obliged, Lordship.
Item 33. May I please, your Lordship. Lordship, in this case, I was supposed to file an affidavit in reply. So I pray for further 1 week time to file the same.
What's the matter about?
It is regarding the construction of a 5th and 6th floor of a building.
Yes, 5th and 6th floor, they have already submitted their explanation.
They have submitted their explanation, but it is not factually correct in certain cases.
Sir,
So,
on 7/6/2000, 1 month before, we have granted you time to file.
Lordship, actually, due to some of my personal inconvenience, I could not file. I can file it by next Monday.
Counsel for the petitioner appellant pays some more time to file counter to the response filed by the state. Rest of 2 weeks.
Matsud.
Item 34.
My lord, here in this case, my lord, the
The last occasion,
Railway Authority and the Pollution Control Board were directed to file affidavit.
Pollution Control Railway Department furnish the factual report to the whether the pollution has been contained in the Lanka Reyes.
Yes, the railway has taken steps for to protect the pollution and contain.
What is the level of the pollution? Now it is contained or not?
Yes, contain proper
Where is the
drainage.
report?
Yes, I have received the report.
Place
My
it
lord.
on record. Where is the report?
Absolutely wrong, my lord. We have also got some photocopies of yesterday. The loading and unloading is going on openly, my lord, in a loose arrangement.
Right, loading and unloading.
And in
What
that
they have
connection,
said, they've taken protective steps to so the pollution may not be caused. Whether any such protective steps are taken or not.
that report is not submitted, my lord.
That-
We have filed an additional affidavit yesterday.
Report is, I will, along with photographs of it. I have received.
What photographs?
आज ही फाइल करी सुने
So now it is totally contained.
Yes, we have.
No,
take
my lord.
steps, Lord.
We have filed
Yes,
today an affidavit, my lord, showing that the loading unloading in open arrangement is going on, my
So
lord.
the loading, unloading, we have not stopped that loading, unloading. We simply asked them that the protective measures should be taken so the pollution
Yes,
will
ma'am.
not spread.
Without protective measures, they are doing, my lord. Till now, my lord.
File your
Yes, yes, Lord.
this learned council appearing for the pollution control.
I am for railway.
Who are-
Lordship.
You are for the railway.
From 9 and 10,
Who are the 9 and 10?
Brahmi Cement.
And pollution control you are for. What is your report? Whether the pollution is in under control or not?
Yes, all the preventive measures that they have.
What do you mean by preventive measures? Even though despite that preventive measures, whether the pollution is in control or not?
That ambient air report is not with me, but
Why then, what you are doing if the report is not with you, it's a matter of pollution department only.
only yesterday they have filed an additional affidavit saying that subsequent to our closure notice,
Sir,
again, they have been
On the
going on.
last occasion, Learned Council appearing for the Pollution Control Board and Railway Department. But directed, who is for the, madam, why you are not filed factual report? This is file an affidavit.
Yes, affidavit is ready and signed for vetting. Lord. Yeah, speaking.
Do it by next week.
Yes.
And you also, yes, Mr. What's your take? SR Gogoi, what's your take? You are for the private respondents, the contractors or the persons who are loading cement?
Yes, my lord.
So what measures you have taken?
You have only filed an affidavit, you are setting in paragraph number 11. Combined affidavit. You have erected, that scale of 80 feet high. Affidavit filed on 21/3/24. 21/3/24.
Pollution Control Board, you are for the pollution control? Yes. Measure the pollution level and then submit a report.
Yes.
Whether it is within permissible limit or not. Okay. One concept for the railways has furnished a factual report. For provision of the report. We direct the council for the railways to file the factual report along with the affidavit of the concerned officer within a period of 1 week. Full stop. The Pollution Control Board has not filed any factual report. We also, we grant 1 week's time to the council for the Pollution Control Board to file an affidavit explaining the explaining that file an affidavit detailing out whether the pollution level at the Lanka railway station during loading and unloading of fly ash, clinker, pet coke, coal and cement and other raw material is under the permissible limits or not. List on. When after the week. 20th of August. No, sorry, 20th of August is get out. 6th of August. 6th of August.
Deep level university. Item 35.
Well, in this case, earlier petitioner is supposed to file a reply. Not yet filed.
None present. 4 weeks.
For hearing item 41.
Directly 41. Bagi se bagi. 41 gaya.
Meet with the lordship. In this case, I am led by Mr. D. Das, but he is on legs, my lord, in other court, my lord. So I will start, my lord, let him come, my lord.
We'll take up it next week.
My lord, I will
Next
start.
week. Next week.
Thank you.